Hello, everybody, and welcome to the Safeguard Estate and Financial webinar. Thank you all for coming. My name is Jeff Sykes. I'm your speaker. I'm sitting here with my friend and associate, Robert Levin. What we're going to do today is we're going to try and teach you about estate plans. We're going to teach you about your vulnerabilities, and we're going to teach you how to solve those vulnerabilities. The company I work for is Safeguard. We're an estate planning firm in Arizona, and what we do is we specialize in estate planning, and what that means is we provide turnkey estate plans for our clients. We have over 20,000 clients in Arizona. Our team has over 50 years of experience. What I'm going to do is I'm going to explain to you as we go through this what a turnkey estate plan looks like. Our office is in Scottsdale on 1405 North Hayden Road. Here's a picture of the office, the waiting room. So this is the part where I have to tell you that I'm not an attorney, so I'm not here to give legal advice. I'm here to teach you about estate plans. If you do business with Safeguard, ultimately you'll be meeting with our attorney. His name is Mark Hall, Mark E. Hall. He's been an estate planning attorney in Arizona for over 20 years. He's a specialist. He specializes in this field, so he really knows what he's doing. And that's important when you're in any kind of endeavor legally that you're going to go down. You want to explore that with an attorney that specializes in the field, and that accomplishes a couple of things. You're not dealing with an attorney that's learning on the fly, so you're going to get proper service from somebody that's competent. And in the end, that usually saves you a lot of money, because people that do this for a living, they're efficient. They have a process, and you get a proper estate plan done, and you get it done at a great value. Mark's a good man. We've all been on this planet long enough to know that attorneys aren't always the best people. Mark is a nice man. He's not the kind of attorney that's gonna, put you on a timer every time you call him. If you do business with Safeguard and you're one of Mark's clients, he's gonna take care of you. If you have a question down the road, he'll take your call, answer your questions. He's a nice man. He's got a nice family. I'm honored to be working with him. Okay, so let's kind of get this started. There's three types of people that tend to come to these webinars. And so the first type have nothing in place, here in the tumbleweeds. The legal term for having nothing in place is called intestate. And what this basically means is if your estate's over $75,000, your family's going for a ride, a nasty ride. They're going to go to probate. And so if you're in that category, you came to the right place, because I'm going to explain to you how to fix it. The next people that come to these things have a will in place. A lot of people have wills, but in the last decade or so, it's kind of emerged. A will is not always the best solution. There's a place for a will, but wills have a lot of vulnerabilities. And so if you're here wondering if your will's good enough, well, I'm hoping to teach you whether or not it is. So hang tight if you have a will in place. And then some of you have a trust in place. Now, a trust is the best way to protect your estate. If you want to stay out of probate, for sure, a living trust will do it. So if you do have a living trust in place, congratulations. But people that have these trusts in place, some people, they have questions, or maybe they need to make changes and they want to know how to do that. They want to know if there's any laws changed, or they just want a refresher. Well, you came to the right place, because we're going to go over all of this stuff. And so let's kind of get started. The first thing we need to talk about is the problem, probate. It's what we're all trying to avoid. It's not the only problem, but it's generally it's that elephant in the room. Probate is nasty business. This cartoon kind of illustrates that perfectly. Well, let's talk about probate. What it is, what it does, why it exists. Here on this slide, probate is the judicial process where a will is proved in a court of law and accepted as the valid public document that is the true and last testament of the deceased. That what probate court is essentially doing is they're taking your assets and they're deciding who owns them. What happens is you own your home. If you're a husband and a wife and you own your home, the two of you own it. If your deed is done properly, you're in a community property state in Arizona, it should say the husband and or the wife owns the home. Husband passes away, now the wife is the survivor, she's the owner of the home. Usually not any issues. It's worth mentioning, you should probably take a look at your deed if you can. Some people have bought their house 20 years ago. When you bought the house, you signed a stack of documents a foot thick, and some of you have never gotten a copy of your deed. And because you go through all those documents, and escrow companies can rush through things, mistakes can be made on deeds. But in this case, we're going to assume that the deed is done correctly. So now the wife owns the home. When the wife passes away, she essentially takes ownership of the asset to the grave. Now, who owns that asset? See, a judge has to determine who owns it. That's what probate court exists for. They find who owns an asset that no longer has an owner on the title. But what I want you to take note of here is probate is the judicial process where a will is proved in a court of law. Think about what that implies when we get to the part where we talk about wills. And we'll go back to that. So let's talk about some of the other elements of probate. One of the nasty things about probate is it's expensive. You never know what it's going to cost you. There's no structure to it. It swings wildly. And when I say that, what I'm talking about is this: your probate costs, the cost for the court, 6 to 22% in the state of Arizona. There's complications that can occur in a probate case. More people can make claims. There can be issues, deed issues. There can be multiple wills. There can be all kinds of things that can cause things to muck things up. Having a larger estate, having more assets to deal with, can cause the cost of the court costs to go up or down. For this example here we've got a $500,000 estate, and in between that 6 and 22%, because it's simple, we went with 10% with the court costs. It's a nice round number, and it's on the low end of the average. But when you go to court, you got to hire an attorney, and they're going to get about 10%. So here is a pretty typical cost for your probate case. 20%. So if you have a $500,000 estate, we're talking about $100,000 in courts and attorney's fees. So one of the good and primary reasons to avoid probate is, quite simply, it's expensive. It could be more and it could be less, but here's kind of an illustration of kind of the issue about probate. And another thing, probate is an aggravatingly long waste of time. In the state of Arizona, you're looking at a 1 to 3 year average. So if you get out in a year, you're lucky. That doesn't mean that there are some simple little things, informal cases that don't get out less than a year. But in most cases, it can take you 6 months to get a hearing. And the reason for that is right here. At any given time, there are more than 20,000 active or pending probate cases in Maricopa County, with more than 500 cases being filed each month. Excuse me. So you're talking about it's time and expense. It's an aggravating process. And lastly, you lose your privacy. If you go to probate, everything that happens in a courtroom is a public record. So anybody can go to the clerk's office and find out everything about your life, your estate, who's involved in it, how much you have. It's pretty intrusive. A judge will assign somebody to be in charge of your case, and they'll instruct them to put an ad like this in 3 newspapers or publications for 6 months. And this is just insult to injury. What you're basically doing here is you're inviting people to come in and make claims, extend that probate. And so that's kind of the ins and outs of probate. So what I'm going to do is kind of give you an illustration on how it happens. It's pretty simple. What you're looking at here is title, ownership. Think of the title of a home. You got the husband and the wife, they own the home. Okay, so if the husband passes away, you have the wife, she owns the home. But when the wife passes away, who owns it? Excuse me. Nobody owns it. And that's how you end up in probate. It's pretty simple. There are different ways to defend yourself. And I'm going to discuss one of the ways to defend your estate from probate. The first way you can defend yourself is with wills. Okay, so let's talk about some of the dynamics of a will. It's got some weaknesses. The primary weakness, a will is designed for probate. Remember that slide we looked at the beginning where probate is the court where a will is proved in a court of law? Well, that means exactly what it says. Doesn't mean all wills end up in probate, but you have to think about what a will is. A will is a list of things that you would like to have happen. Wishes, they're not legally binding. So you create this will, it's a document. I would like this to happen. I want my son to receive this. I want that to happen. The will was intended to go into the courtroom so the judge can use it as a guideline on how to distribute your assets. You still have assets that you've taken ownership to the grave, and that's your biggest problem. One of the biggest reasons a will ends up in probate is because you have this asset, the second spouse passes, Nobody owns it. And then you have a will that says what you'd like to have happen. And then you've named it executor, and the executor basically has instructions that they try to follow. The problem comes in with the permissions and who will accept that will. The executor may not necessarily have the permission to sell the home and liquidate the home. There's not necessarily any implied permission there. They may have to go to a judge, have a judge and put a court order behind those wishes in the will, make them actionable, and then your executor can now get permission to sell the house, and the escrow companies will work with them. Or you may have a will and you have a bank account, and the executor goes into the bank and the bank may not accept that will. There's a lot of ways that you can end up in probate with a will in place, but that's one of them. You know, the second thing is a will can be contested. What you have to understand about your estate is when you go to probate, they're not contesting your will per se. What they're doing is they're making a claim on the asset that doesn't have an owner in place. And so you have a will, and then you have people making claims on the assets. And, you know, you have a pretty big problem when it comes to different types of families. If you have people in your family that tend to argue, you know, anybody can make a claim on the will. It doesn't matter what it says. I can make a claim on your will. Your neighbor can make a claim on your will, because what they're doing is they're making a claim on the asset. And the problem is once the claim is made, it's got to be heard. So you have this will, even if you have a family that gets along, it could be anybody in the family that disagrees, and they can take your estate into probate. Contesting is a real thing. And because it can be contested and everybody knows it can be contested, you've laid the groundwork for family disagreements. People are going to start negotiating with each other, for lack of a better term. And then the last thing is it's the loss of privacy. I want to expand on the privacy. Look, it's not only somebody going to the clerk's office to find out what's going on with your estate, but if you pass and you're in probate, a judge is going to freeze all of your assets. They're going to freeze your home. They're going to send out auditors into the home. They're going to send people in there. They got to evaluate your estate. So they're going to open every drawer. They're going to count every dish and everything in your house. What ends up being just somebody going to the courtroom and losing privacy is a lot different than having them actually invading your actual home. But that's what happens when you go to probate. So these are the things that people want to avoid. And so, you know, there's all kinds of different things we look at. When we evaluate an estate and we're going to determine how we're going to protect it, we have to look at certain things. Family conflicts, blended families, do you trust everyone? You know, and straight up the size of the estate. The bigger your estate, the larger that 20% haircut you're getting in the probate court looms. And so sometimes you can have the greatest family dynamic there is. If you've got a large estate, do you want to put it at risk with a will? It's kind of like in your insurance. If you've got a $50,000 car in your driveway, you're probably going to put comprehensive insurance on it. If you've got a $2,000 beater, you may not put comprehensive insurance. So the size of the estate comes into effect. So let's talk about some of these issues. Blended families. This is a very, very common thing nowadays. People, they get married later in life. They have children from previous marriages. Wonderful thing in most cases. But it's been our experience that when these married people pass away, what's left behind often ends up as warring tribes. And these kind of estates typically end up in the probate court when there's nothing but a will in place to protect the estate. So, you know, if you have a blended family, this is one of those red flags where a will may not be adequate for you, even in a smaller estate. And the next thing is family conflicts. Look, there are some families where conflicts are just part of the dynamic of the family. Some kids, the sibling rivalry starts at a very young age and it goes on. There are parts of my family, some parts of my father's family, you never know who's talking to who, and it never ends. These kind of things you have to consider when you're thinking about how you're going to settle your estate. A will could be an issue. And, you know, do you trust everyone? You have to think about the people in your family that aren't necessarily part of your core family. Nieces and nephews, sons and daughters-in-laws. There's people, because you got to remember, they whisper in your sons and daughters' ears. It just takes one person to upset the apple cart. So, you know, you have a vulnerability with a will. It's much better than having nothing in place, much better than the tumbleweeds, but there are strong vulnerabilities. If there's any questions here, I didn't mention this earlier, please submit your questions. Bobby's here to take them. He'll read them out here, and we will get your questions answered. I'm covering all these things. I don't have any feedback where I can actually see you. So if I'm not mentioning something that you have a question, please, we encourage the questions. It's good for everybody because they might have those questions too. So by all means, we're taking your questions. Okay, so let's move on to trusts if there's no questions, and if there is, please ask them. A trust is a different animal. It acts differently. It operates differently. And so let's talk about how it works. I'm going to give you kind of a rundown. A trust, what we're talking about is a living trust. It's a living document, which means it can be changed as long as there is a trustor. When you see the word trustor, I want you to think owner. When you set up a trust, the first position in the trust is the trustor. That's the person that creates the trust, and they own the trust. In the case of a married couple, it's co-trustor, owners and managers of the trust. The next position is trustee. When you hear the word trustee, think manager. The trustee is the manager of the trust, which means they're the person that changes things. They can move assets in and out of the trust. They can move the participants in the trust. But as a matter of fact, the trustor and the trustee are the same person. If you create a trust, you're the trustor, but you're also assigned as the trustee. So in the case of a married couple, you'd be co-trustor, co-trustee, owner and manager. The next position in the trust is your successor trustee. The successor trustee, think of the word manager again, successor manager. The successor trustee's job is to come in and manage the trust after the death of the second trustor. So let's discuss this a little bit, and let's do a little comparison with a will and how it actually affects your family. So when you have a will, the similar position would be executor. So the executor is who you leave behind to be in the will. Well, when you have a will, distribution is limited. And what I mean by that is this: the will doesn't own anything. So if your executor is in fact successful in transferring assets, everything goes in a lump sum. There is no alternative to that. And for some families, that's perfectly fine. For some families, that's a disaster. If you have a family member that's a substance abuser, giving them a $300,000 check could probably end up being a very bad thing. Or if they're on disability and they have benefits, if you give them a $300,000 check, it will interrupt their benefits. Well, with a trust, think of the trust like an ownership vessel. It's like a box you put your assets in. Your trust now owns the assets and you own the trust. What that does is it gives you flexibility in how you distribute, because when you pass away, the assets still stay in trust. They can then be distributed over a long period of time, which gives you flexibility. That person on disability can now be given a monthly stipend that falls underneath the threshold that will not interfere with their benefits. That alcoholic that you love, but you can't give them a lump sum of money, you can now give them a couple $1,000s a month or whatever suits you. You don't have to leave them out. You may just have younger people, irresponsible people. You give them a $300,000 stake in your life savings, your legacy, and they're just going to go out and buy a car, buy a boat, throw a party, and in 6 months that money is going to be gone. Well, with the trust, it allows you to distribute your assets over a period of time so that you can protect these people from themselves. You can also set it up so that the money can be given to your children, and then money can be held, quote unquote, in trust and set up with a minimum age of distribution, and you can give your assets to your grandchildren. Some people with a will, they'll basically give everything to their kids, and then they'll make an arrangement with the kids to give the money to the grandkids. But that's all based on faith, and how this works. If there's money problems, that money disappears. Grandkids are going to get nothing. With a trust, because of the dynamic of it being an ownership vessel, it allows you to control your assets from the grave. It's kind of a wonderful thing in that respect. Also, when you set up your trust, it's a living document, which means it can be changed. You as the trustor can change the trust. When you pass away and your successor trustee comes in to manage the trust goes from a living document to an irrevocable document, which means it cannot be changed. And what that does for you is it means that your successor trustee can't change it. It can't move it around. So they have a legally binding document. And so your successor trustee is now legally bound to follow your instructions, which means this: if they don't follow the instructions, if they violate your instructions, because the trust owns these assets, they're committing a crime, theft and fraud. There's legal teeth. Also, your successor trustee has a no contest clause to back them up. So if somebody in the family comes to them, says, I don't agree with this, they're simply going to read the instructions to the trust. Look, this is what mom and dad wrote. These are the instructions. I can't change it. If you try to change it, the no contest clause says you lose your share automatically. So it pretty much ends the fights. A trust provides a platform for peaceful distribution, keeps the harmony in the family. Well, let's contrast that with the executor of a will. The executor of a will is not legally bound to follow the instructions in a will. In fact, if the successor trustee, if the executor were to sell your assets and keep all the money for themselves, they would have broken no laws. They could literally keep everything and then force the other people in the estate to have to sue them. Well, that's not generally the problem. The problem is you don't have legally binding instructions, so there's a fudge factor. And this is where the platform for kind of a mess comes in. You have this executor who doesn't want to go to probate. So if somebody in the family comes to him and says, hey, look, I'm not happy, that's not what mom says. Well, the executor can say, okay, look, how about if we give you this, a little bit of this? Will that make, okay, that'll make me happy. Well, now you got somebody else in the family who's going to say, hey, wait a minute. You just set the stage for a nasty fight within the family, which often ends up in probate. The nature of the two documents has a completely different outcome on families because of what's allowed as far as what can be contested, what can be changed. So there's no motivation to challenge a trust. Nobody gets anywhere. If you hire an attorney and you try to take it to court, you lose your share. Everybody kind of has to go along for the ride, which gives you control. You're literally controlling your assets from the grave. Wonderful thing. So let's talk about the fourth position. The fourth position is beneficiaries. Your beneficiaries, that's who's going to receive your assets. You could name anybody as a beneficiary. Both wills and trusts have beneficiaries, but the biggest difference in your beneficiaries is the ability to be flexible in your distribution. As long as you're alive, as long as one of the trustors is alive, the beneficiary can be changed. You can change the amount they get. You can add people. You can remove people. It's very flexible. You have complete control of your estate. So let's look at a trust estate. So here we're back to that same slide. John and Jane Smith, owner of the assets. So when you create a trust, you've got we call this the Smith Family Trust. John and Jane Smith own the trust. And what we do here is we move the assets into the trust. And now you have a trust estate. So let's talk about this part of it. What you just saw there, in this, we call that funding. Funding is the word we use for putting the assets in the trust or attaching the assets to the trust. Kind of a misnomer because we don't really put anything in the trust per se. The trust is an ownership vessel and it goes on the title of your assets. So initially when you create the trust, you have to go through this process of funding. What it essentially entails is this: we have to take assets that are in your name and put the trust on the title of your assets in place of your name. You own the trust owns the assets. This is how you create that continuous ownership that removes the ability for a courtroom to get standing. So when we do this process, we do it when we deliver your trust. So when we create your trust for you, the first thing we do is we put the trust on the deed of your home for you, which basically means we pull up your deed, you sign it, it's witnessed and notarized, that puts the trust on the title of your home. The next thing we do is we walk you through the process of all of your other assets. When you put your trust on the title of your home, it creates a residual estate, which basically means it covers your home, everything inside the home, including your automobiles, which is very convenient. So through the residual estate, if you pass away, your successor trustee will have all the permission they need to liquidate your vehicles. Very convenient for you, because vehicles are very disposable assets. Chances are what you're driving today, you won't be driving 5 years from now. But because of the way the trust works and creates a residual estate, you can buy and sell cars and they'll automatically be added to your trust or removed from your trust. It's a very nice feature. Well, anyway, that funding process, that's one of the things that separates us from typical attorneys. That's where the turnkey estate plan comes in. One of the things that I deal with on a regular basis is I meet with a lot of people in their home. As an estate planning consultant, that's my job. There's people that have a trust in place. They've had it 10, 12 years. And I'll go to their house and I'll meet them and I'll start going through all the elements in the trust, making sure that it's up to snuff, it meets all their current wishes. And I'm going to say 30-40% of the time, they'll have had that trust in place for 12, 10, 15 years, and there's not any assets funded into it. That's because they went to an attorney, and the attorney created the trust. He left a checklist in the front that they didn't bother noticing. They put the trust on a shelf, and they checked that off in their mind. They thought they had everything in place. Well, if there's nothing in the trust, there's nothing for it to protect. So what they had was essentially a paperweight. One of the things we do at Safeguard is we are going to take you through that funding process. We are going to make sure that you would never, ever have that happen to you. In fact, we're going to stay with you. We're going to create your trust. We're going to fund your trust. And then we're going to call you every year and a half or so, and we're going to make sure that you didn't make any changes that don't need to be addressed. And if you did, we're going to help take care of that for you. We want to make sure your trust stays funded properly from the moment you sign it all the way through the rest of your life. That's one of the benefits of doing business with Safeguard, is we're going to make sure that happens. So now let's talk about how a trust, what it looks like when you settle it. Okay, so now John Smith, he's one of the co-trustors and trustees. He passes away. That leaves behind Jane Smith. Now, Jane Smith is the surviving spouse, and she's in control of this trust, is the owner and the manager. She has full authority. What's nice about a standard living trust is Jane Smith doesn't have to get permission. She still owns everything. If she wants to sell the house, she's going to sell the house. If she wants to buy a new car, she'll buy a new car. If she wants to take money out of the bank, she'll take money out of the bank. If she wants to open up a new account, she'll open up a new account. I'm going to show you what happens when Jane Smith passes. Okay, now, if you didn't have a trust in place, you would have a question of who owns this property. If you're not here, who owns it? Nobody. Well, in this case, if you're not here, who owns it? The trust owns it. So what happens is the successor trustee simply comes in as a change in management. The successor trustee is now in charge of managing this trust. What this trust just did is create continuous ownership. It essentially makes your death a non-event when it comes to your assets. The day before you passed away, you owned your trust. The day after you passed away, your trust owns your assets. Your successor trustee comes in to manage your trust. Now the successor trustee has a legally binding duty to follow the instructions in the trust. No probate. It's not possible. With the living trust in place, there is no lapse in ownership. What that essentially does is it allows you to have a very smooth, very easy transition when you pass away. Your successor trustee doesn't need permission from anybody. They simply get your death certificates and they can go to settling your estate. And I'm going to talk more about settling your estate as we move through this. And so what I just talked about there, what we dealt with was the ownership of your assets. And to boil that down, to review that, it's this simple. Take a look at anything you own and ask yourself this question. If we're not here, who owns it? If you can't answer that question with a legally binding pathway to transfer that asset, a judge from the probate court is going to answer it for you. Too much expense and time to your people you leave behind. When you have a trust in place, the answer to that question, if we're not here, who owns it? The trust does. It's really, really a wonderful tool for passing your assets to your beneficiaries. Another benefit when you pass your assets through a trust, when you get older and up there in age, what a lot of people like to do is people will say, I'm just going to put my home, I'm going to add my daughter to the title of my house. That way, if I pass away, she's the owner. We highly advise that you don't do that. You create problems for yourself on a few different fronts. Number one, you create liability issues for yourself. If something happens, the IRS comes after your daughter, she gets in an automobile accident, even if one of her kids do something that causes her to be sued. Well, and she has an ownership stake in your home. So you can potentially lose your home or have your house drug into a lawsuit. If you do that, you're creating problems, and you may think it's going to be okay, and it always is okay until it's not. Well, the next element that you create is you expose them to capital gains. So here's how this works. So you put your daughter's name on the title of your house. They don't just inherit your home, they inherit your tax basis. So think of it like this. Say you've owned your home for 20 years. You bought your house in the year 2000. Okay, and you put your daughter's name on the house. A couple years go by and you pass away. Well, say you paid $200,000 for the home in the year 2000, and it's now worth $500,000. So it went up in value $300,000. That $300,000 capital is I'm sorry, excuse me. That $300,000 rise in value is exposed to capital gains. So now when they go to sell the house, they're going to have to pay 22% of a large portion of the value of the home, whatever it appreciated. That's your tax basis. Your purchase price is your tax basis. Well, when you pass your assets through a trust, they're going to receive the asset at the current market value. You're going to eliminate their exposure to those capital gains. Just that alone, in a lot of cases, is enough to trigger people to use a trust as a means of distributing their assets. So now let's look at the next element. There's two things you have to protect yourself against. The first aspect is ownership. We just talked about that. The second aspect is your decision-making prospects. Here's the thing. This is your reality. If you get into a situation where you cannot make decisions for yourself and you do not appoint people that you know and trust to step in and make decisions for you, a judge is going to step in, appoint an attorney from the court to make those decisions for you. And so let's talk about some of this. When does a will take effect? Well, when you sign a will, it has no effect on your life. A will doesn't come into play until you pass away. Well, the problem with that is it can't protect you if you're still alive. So if you become incapacitated, the will has no bearing on your life, not until you actually pass away. Unfortunately, things can happen to us that render us incapacitated. In fact, statistically speaking, that's probably going to happen to most of us. I would love to tell you that we're all going to get really old and we're just going to crawl in bed one night and just pass in our sleep. Unfortunately, most of the time that doesn't happen. And if that doesn't happen and you haven't appointed people that you care or that care about you to make your decision, you can lose control of your estate. Who's going to make your medical decisions, your financial decisions? How much is it going to cost? Where are you going to be cared for? These are important decisions that you want people in your family making for you. So let's talk about a trust. When does a trust take effect? Well, a trust takes effect when you sign it. So when you set up a trust, what it does is it allows you to put people in positions to make decisions for you because the trust protects you while you're still alive. And what I'm talking about is these kind of things: stroke, Alzheimer's, mental incompetence, car accidents. You know, if you end up in these situations and you're rolled into a hospital and you're unconscious, you know, you can't sign documents. You can't give people permission. You know, most people here have been in the hospital for one reason or another. You schedule a surgery. You know, you're going to have your knee replaced or you're going to have a broken arm fixed. When you go into the hospital, you're walking in there on your own power, and they make you sign a rather large stack of documents. And within those documents, you're signing permission. If, say, something goes wrong with that surgery, you're giving somebody the ability to make a decision. I need to do another surgery. Can we do it? No, I want to get a second opinion, or yes, do the surgery. And you're also assigning somebody the ability to make a limited financial decisions. You know, say you have a stroke and you're in the hospital 3 months and you're going through therapy and you need somebody to be able to pay your light bill, pay the car payment, make sure that your mortgage gets paid. So when you recover and you come out of the hospital, you're not coming out and in with a foreclosure notice on your door, no electricity. That's one level of decision making. Well, when you end up in the hospital and you're not conscious and you can't sign paperwork, you have to have paperwork already in place. You have to make sure that you've assigned somebody with that permission. And so what we're talking about is power of attorney documents, medical power of attorney and financial power of attorney. There's two levels of incapacitation. If you're incapacitated in a meaningful way, something longer term, something more serious, something above and beyond what a power of attorney document will give the permission, We're talking about conservatorship and guardianship. Your trust allows you to assign somebody for that position. Conservator and guardianship, when you set up a trust and you have two married people, trustors, those co-trustors are also named as each other's conservator and guardian. Now the successor trustee is assigned to the surviving spouse's conservator and guardian. So what that essentially does is it allows you to fill that role no matter what happens to you. From the time you sign your trust all the way through the rest of your life, you've put somebody in a position to be able to make decisions for you in the event that you can't make decisions for yourself, no matter how bad the problem is. If you have to put in a home and you need a conservator, you've put somebody in a position to make those decisions. It's much better to have somebody that cares about you making those decisions than an attorney from the court, because we're talking about what type of facility, what level of care, how much it costs, what assets are going to be sold to pay for it. You know, if the court gets a hold of your estate, there's probably going to be nothing left by the time they're done. And the care that you get is likely to be substandard because the person that's putting together your plan doesn't know you, doesn't care about you. They're probably dealing with 50 other people. When it's your family, you're talking about somebody that loves you and knows you and cares about you. One of the best things that a trust does is allows for this. So let's talk about this. Incapacity. You know, without a plan, who makes your decisions? Others make decisions for you, including the state. And so let's look at an example. I don't know if you remember, this was Terri Schiavo. She was a 27-year-old female in Florida. She had a heart attack. She was in a coma for 15 years. Well, look, she went into the hospital. She was unconscious. They hooked her up to life support. She wasn't able to give any permission to anybody. And, you know, one of the things that people ask me, you know, I have a husband, I have kids. How can this happen? Here's the thing. If you don't appoint them, legally appoint them to make these decisions, they don't have any power to make these decisions. And so what happened was the husband went to court for 8 years. She sat on life support, and he went to the court and he fought his case, and he finally won conservator and guardianship over his wife. 3 days later, it was reversed. So the feeding tube comes out. 3 days later, they put the feeding tube back in. Guess what? Mom didn't agree. Mom didn't want her to come off life support, so she contested it. The key here is no documents were in place. No intentions were laid bare. Nobody was given power to make decisions. So it became a family within a fight within the family. And so when you set up a proper estate plan, you're going to put somebody in a position to make these decisions. So this cannot happen to you. Can you imagine what this cost that estate? Think about what it costs to be on life support just as a daily number. It's got to be in the thousands. Imagine after 15 years, a proper estate plan allows you to keep control of your estate no matter what happens to you. And here's what I'm talking about. This comes straight off of the Judicial Branch of Arizona website. Judges and commissioners assigned to the Probate and Mental Health Department oversee over 9,000 active, commissioners assigned to the Probate and Mental Health Department oversee over 9,000 active guardianship cases, over 500 million in conservatorship assets, and over 3,000 active orders for treatment. This is one county in Arizona. There's 9,000 people. They've been made wards of the court. Typically, when you have a married couple, even if you don't have a trust, there's some safety in numbers. You can take care of each other. But, you know, typically the real threat of this is, you know, say the husband passes away. Well, now you have the surviving spouse and she's alone. She doesn't have any documents in place. She hasn't named her kids to step into that position. So she has a bad stroke. She goes into the hospital. There's a competency hearing. The judge declares her incompetent, and she becomes a ward of the court. And now a stranger from the court is assigning where she's going to go. She can end up in some county contracted facility, maybe not the best care, sell the house to pay for it, close all the investment accounts. That's kind of the nature of what happens in these cases. I bring it up simply because it happens. I mean, this is kind of a 9,000 people. You know, this is kind of a rolling number that kind of stays there. Somebody passes away, another one comes in, and $500,000 in assets is a lot of money. And so the only way that you can protect yourself from ending up having the court assign you a conservator or guardian is with the trust. Because the trust is an ownership vessel, and because the trust doesn't pass away, you can set your family up to be your conservator and guardian. It's a wonderful thing. And so when you're talking about a turnkey estate plan, you're dealing with every element, anything that can possibly happen, you have covered. And what that means is you've got power of attorney documents, somebody to make your healthcare decisions and your financial decisions. You've named a conservator, so you have conservatorship. And finally, you've given an authorization to physicians, a living will. That's the final kind of key to this. If you end up on life support, you want to have your intentions stated. You don't want to leave that question open. What a living will does is it allows you the right to die naturally. So if you end up on life support, you have a living will that basically says that if two doctors of the same specialty determine that my death is imminent and that I'm not going to return to any quality of life without the life support, you choose to be disconnected from life support and allowed to die naturally and comfortably. And that accomplishes a few things. So the first thing it accomplishes is it doesn't allow for you to be on life support for a prolonged period of time, which basically first the hospital will absorb your insurance and then the hospital will absorb your estate. So it allows you to preserve your estate. And then secondly, and maybe more importantly, it removes the guilt of that decision from anybody in your family. Nobody is going to go home, lay their head on a pillow, and have to think about they had to kill their mother. I had to unplug mom. It's just something that you can make a decision and then it's executed and it's your decision. No guilt left for anybody in the family. And so I've got to ask, you've worked hard your entire life for what you have. Don't you think it makes sense to protect your estate before you pass on? That's what we're here at Safeguard to do, protect your estate. And so let's go here. Everybody knows Susie Orman. If you don't, she's one of the financial commentators. And what she says here is a revocable living trust allows your heirs to avoid probate entirely, keeps you in complete control of your finances while you're alive. You can always make changes to what's in the trust and how you'd ultimately like it managed or dispersed. I'm going to paraphrase that a little bit. I'm going to kind of explain. This is what I think she's telling you. Look, when you set up a trust, and initially we go through that funding process, the retitling process. Once that's done, a trust is not difficult. It does not change the way you go through your daily lives. It does not interfere with your interaction with your assets. And I'm going to give you some examples. Okay, so you put your trust on your bank account. And so the trust owns the account. That doesn't mean you can't put money in the account or take money in the account. You're going to do that like you always have. Also, if you want to close the account, you just walk in the bank and close the account. That account is no longer exists. It's now not part of your estate. Moving forward, if you want to open up a new bank account, once your trust is in place, you title your assets as you acquire them. So you walk into the bank, you bring your trust with you. Hello, sir, I'd like to open up this account. Here's the cashier's check. I have a trust. I would like to put the trust on the title of the account. So you open up the account, the trust goes on title. Now that account becomes part of your estate. Same thing with your home. If you have your trust on the title of your home and you want to sell it, you sell it. It goes into escrow. It clears escrow. The new owner's name goes on the title. Your trust comes off the title. And now that asset leaves your estate. If you want to buy a new home, you take your trust into the process. When you buy the home, you make an offer, it goes into escrow, and you simply tell them, I have a trust. I want it to go on the title when it clears escrow. The house is going to clear escrow. The trust goes on the title and that becomes part of your estate. Very, very simple moving forward once your trust is in place. It does not interfere with your day-to-day activities at all. Makes it very, very, very simple. Okay, so the burning question you guys are probably after right now is, how much does it cost? Well, I pulled this out of a magazine, Kiplinger's, and this just talks about the averages. You can basically get a will, basic trust, power of attorney, your living will, everything you need in a trust, all the documents that'll properly protect you. $2,500, $3,000. I'm going to say that's probably accurate. Doing what I do when I review a lot of trusts, they usually keep the receipts right on the inside cover, and so I can kind of see what the costs are for getting a trust, and I would say that's pretty accurate. If you come into our office and you talk to our attorney, Mark, his regular price is $19.95. Start to finish. We have an offer though. People that are willing to come to these webinars and sit through these webinars, we have a half price offer. If you are interested in moving in a trust, and you know you need to do this, we're offering a $9.95 price, and that includes everything. That includes the attorney, that includes the funding, and more importantly, that includes the settlement services. One of the best things that we do as a company is we're going to help your successor trustee settle the estate. I'm going to kind of give you I'm going to clue you in on what happens when you're with your estate. Unfortunately, estate plans can be basically robbed blind after you're gone. Attorneys will turn your estate plan into their retirement program. Wills are typically the culprit. I'm going to explain to you how this happens with a will. So you create a will, okay? You go to an attorney, you create the will, you put everything in place, says what you'd like to have happen. You fold it up and you put it in an envelope, and right on the front of that envelope is the attorney's name and number, perhaps even on the will, the attorney's name and number. You put that envelope in a safe place and you let your executor know right where it is. Well, the attorney put a copy of that will in his filing cabinet, and you know that attorney's just waiting for the phone to ring. Okay, so you pass away, your executor grabs the will, opens it up, and they've never settled an estate before. They don't know what to do. So the first person they call is that attorney. And the attorney goes, "Oh, hello, I'm so sorry." And they'll enthusiastically offer them help. So they'll make an appointment. And so your executor will go into their office. And now they're sitting across the desk from the attorney. Well, what's better for the attorney at that point? Take that estate into probate. Remember, that will was designed for probate. They're all supposed to go into probate. They don't all have to. But what's better for the attorney? Take the estate into probate and bill $300 an hour for 2 years, or try to sell it quickly and easily? Well, unfortunately, that conflict of interest leads your estate right into the probate court. A trust does not need an attorney to settle. You would not hire an attorney to sell your home or get your life insurance or close your bank accounts and distribute your assets. One of the best things we do as a company is when you pass away, when they open up that trust book, right on the inside cover, it says, if you are the successor trustee in the process of distributing assets through this living trust, please notify Safeguard. And what we do is they call us, we bring them into the office, and we basically walk them right through the process. We prioritize everything. We take all the mystery out of the legal documents, step by step. We give them the phone numbers they need to call, and we walk them through the process of selling the estate. And that doesn't cost them anything. That's included in the $9.95 you paid for it. And it's a wonderful thing. The satisfaction that we get from taking a very, very stressful situation, the loss of a loved one, a parent, and we remove the stress, we remove the mystery, we give them purpose, and we get them right through the process. We do this very fast, and it doesn't cost them anything. It's one of the best things that we can give to your family as a gift for doing business with Safeguard. And quite honestly, it's one of the best things we do for ourselves. It might be the best marketing tool we have. You know, generally the people that come in to settle their parents' estate are right about that age when it's time for them to protect their own estate. And the first question is, well, how do I get this from our own family? So it's a very symbiotic thing, but we have a lot of pride in our service. Safeguard is kind of like a family. If you do business with Safeguard, you'll see that. If you're interested in doing this, we have this form that you fill out. If you look at this page here, there's a web average on the bottom. It's http://safeguardyourestate.com/form. You can type that into a web browser, and then the form will come up. You fill that up and you submit it, and that'll give the information so we can call you and talk to you. We can answer your questions, or we can get your trust started. We do it in a couple of steps. We ask that you allow us to earn your business. So you're going to come through the process. If you don't like it, you can back out. We're also going to send you an email, and it's going to have a link to that link, and you can open that link, fill out that form, and we can get this started. Those of you that have showed up and stayed through this, if you fill out that form, you're not obligated. We're going to send you a gift card. And so we have a question here, and please, if you have questions, we're going to keep this up for a few minutes so that you can ask the question. If you have a mortgage, this is from Dennis. If you have a mortgage, can you get a copy of your deed? If so, where can you get it from? Yes, you can get a copy of your deed. It can be done. When we do a trust, we put the home on the deed of your home, and then we file it for you, and you get a new deed in the mail. But yeah, you can get a deed for your home. That's not a problem. Fill
fill out that form, get a free gift card, and we'll give you some details on exactly how to get that deed. It's very, very simple. It's a process. Do we have any more questions? Well, like I said, if you know you need to do this, we would love to earn your business. We're very good at what we do, and we're going to provide you the best value out there. $995 for a proper estate plan with a trust created by a proper estate planning attorney and all the services we're going to provide is a tremendous value. So I want to thank all of you for coming, and we're going to leave this up for a few minutes. And if you have any questions, post them here. But please, by all means, fill out that form, safeguardyourestate.com/form, and we'll call you back. We'll ask some questions, and if we can help you, we'd love to help you.